As we discussed in part 1 of this series, in the Regal Act, Congress directed the federal banking agencies to create an intra-agency appeals process. In response to that directive, the FDIC created its own intra-agency appeals process, and today we're going to talk about that, including what supervisory determinations are appealable, the procedure for filing those appeals, and what to do if you're considering challenging a supervisory determination by the FDIC. So the FDIC hasn't come up with an exhaustive list of which of its determinations are appealable, but it's provided a lot of examples, and those include CAMELS ratings, IT ratings, trust ratings, consumer compliance ratings, and certain other ratings. In addition, it includes determinations that relate to the adequacy of loan loss reserve provisions, the classification of loans and other assets in dispute if the amount individually or in the aggregate exceeds 10% of the institution's total capital. It includes Truth in Lending Act, Regulation Z restitution, and decisions to initiate informal enforcement actions, such as a memoranda of understanding. It also includes determinations concerning an institution's level of compliance with a formal enforcement action, but this doesn't include any decision to bring a new enforcement action that is based on noncompliance. It also includes matters requiring attention, or MRAs, and any other supervisory determination, unless it's otherwise not eligible for appeal, that may affect the capital, earnings, operating flexibility, or capital category for prompt corrective action purposes of an institution, or otherwise affect the nature and level of supervisory oversight accorded to an institution. And the supervisory determinations are not limited to these enumerated categories. They're just some examples. There are some determinations that the FDIC has explicitly said are not appealable in the interagency appeals process. And these include decisions to appoint a conservator or a receiver for an insured depository institution, decisions to take prompt corrective action pursuant to Section 38 of the Federal Deposit Insurance Act, determinations concerning which other appeals procedures exist, and any formal enforcement-related actions and decisions. And that would include determinations concerning the underlying facts and circumstances that form the basis of a recommended or pending formal enforcement action. The FDIC has stated that any institution that's considering filing an intra-agency appeal should first make a good faith effort to resolve any dispute that it has with the on-site examiner or with the appropriate regional office. But it's not necessary. An institution doesn't have to attempt to resolve a dispute with the on-site examiner or with the regional office in order to file the appeal. It can appeal without making any attempt, but it's usually a good idea to make the effort to try to resolve those disputes first. The procedure for the filing is that it has to be filed with the director of the FDIC division that made the determination. And that's either the director of the Division of Risk Management Supervision or the director of the Division of Depositor and Consumer Protection. And it's important to keep in mind the filing has to be made within 60 calendar days of the financial institution receiving the written supervisory determination that is being appealed. The FDIC has specified certain things that have to be included in any appeal. So that includes a written description of the issues in dispute. It includes a description of the surrounding circumstances and the institution's position regarding the dispute, as well as any arguments that support that position. And that includes any citations of relevant statutes or regulations or policy statements or legal authorities. In addition, it's important to describe, and is required to describe, how the resolution of the dispute would materially affect the institution and whether a good faith effort was made to resolve the dispute with the on-site examiner and with the regional office. And again, it's not necessary. It's not required to make that effort before the appeal is filed, but it is required to inform in writing the FDIC whether or not that attempt was made. Finally, the appeal has to include a statement that the institution's board of directors consider the merits of the appeal and authorize that it be filed. Once an appeal is filed, it's reviewed by the division director. And the division director reviews the appeal for consistency with the policies, practices, and mission of the FDIC, as well as the overall reasonableness of and the support offered for the positions that were advanced. Generally, the division director will issue a written decision within 45 days of receiving the appeal. And if the divisional director recommends that the institution receive relief that the divisional director lacks the delegated authority to grant, then the director can transfer the matter directly to the Supervisory Appeals Review Committee, also known as the SARC, without issuing a final determination. An institution that disagrees with the decision of the divisional director can appeal that decision to the Supervision Appeals Review Committee, which is known as the SARC. The SARC has 3 members. The first is the SARC chairperson, and that's one of 3 inside FDIC board members, either the FDIC chairperson, the FDIC vice chairperson, or the FDIC director. And the second and third members of the SARC are deputy or special assistants to the 2 inside FDIC board members who are not designated as the SARC chairperson. In addition, the inside FDIC board member can actually designate the most senior member of their staff within the substantive area of responsibility to act on their behalf. And finally, the FDIC General Counsel is also a non-voting member of the SARC. The deadline for filing the second level appeal is 30 calendar days from the date of the division director's determination. And the appeal must actually be received by the FDIC or placed in the mail within that 30-day period. So what needs to go into the SARC appeal? Only matters that are previously reviewed by the divisional director can be appealed. So if there's a new challenge that you wish to make, you can't raise it for the first time on this level of appeal. In addition, the institution should set forth all of the reasons, legal and factual, for why it disagrees with the division director's determination. And it's important to keep in mind that evidence that wasn't submitted to the divisional director may only be submitted to the SARC if it's authorized by the SARC chairperson. The appeal to the SARC has to be filed in writing. But if an institution seeks to make an oral presentation to the SARC as well, that request has to be noted in the appeal. In addition, the SARC can determine to allow an oral presentation even if no request is made. Once the SARC gets the appeal, it'll review the appeal for consistency with the policies, practices, and mission of the FDIC, as well as the overall reasonableness of the positions that were advanced on appeal. The SARC review is limited. It's limited to the facts and the circumstances as they existed prior to or at the time that the supervisory determination being appealed was made. And the SARC meets to consider the appeal within 90 days of the initial filing of the appeal, and then issues a written decision within 45 days from the date that the SARC met to consider the appeal. Finally, the law is unsettled in this area, but it might be possible to challenge certain decisions of the SARC to a federal court. So if the FDIC made a determination relating to your financial institution, and you don't like it and you want to challenge it using an intra-agency appeal, what should you do? Well, first, if you haven't done so, you should watch the first video in this series, where I talk about some of the strategic implications of filing an intra-agency appeal. And second, because this is a legal process, it's going to involve your counsel. And you want to reach out to your counsel for a few things. First of all, you want to actually ask for permission to disclose CSI to your counsel if that's necessary for your appeal. And that authorization to share confidential supervisory information may have to come both from the FDIC and from the Department of Financial Services or whoever your state regulator is, in the case of joint reports of examination, for example. You also want to consider whether to request an extension of the initial appeals deadline based on the time it takes you to get authorization to share confidential supervisory information with your lawyer. Because until your lawyer has access to those documents that are protected by the regulations that apply to confidential supervisory information, they really can't finish finalizing the appeal that is going to be filed. You also want to consult with your counsel concerning whether the type of determination in question is even appealable, and have your counsel confirm that the procedures and the deadlines have not changed since this video was recorded, because the FDIC actually has updated its appeals guidelines 5 times in the last 15 years. And finally, and perhaps most importantly, because this process is unique and fast-moving, it's important to hire a law firm that is experienced in handling intra-agency appeals.